work. Now, when you look up Alexis on LinkedIn and on his own firm, there's a huge amount of description about his accolades and what he's done, and it puts people like me to shame, really, when you consider what I've done. But Alexis is described as a figure of great renown in the arbitration world and an outstanding star in the field, amongst other things. The founding partner of, and I hope to say this right, Mourre Gutierrez Chessa Arbitration. He served as counsel, president of the tribunal, co-arbitrator, sole arbitrator, or expert in more than 270 international arbitrations, both ad hoc and before most international arbitral institutions. He's the author of numerous books and publications in the field of international business law, private international law, and arbitration law, as well as being a member of a large number of scientific and professional institutions dedicated to arbitration and private international law. That makes him more than qualified, I would say, to speak to us today, and certainly much more qualified than me to spend the next 10 minutes or 15 minutes listening to. So over to you, Alexis.
Toby, thank you very much for your two kind words. Thank you, Atla, as well. And thanks to the organizers, Mike McIlrath, MD, HKA, Omni Bridgeway, SLGC, for inviting me today to deliver these remarks, which will indeed be short. I will not discuss whether investors are entitled or not to reasonable rate of return. Sorry to disappoint you. I'll try to focus my remarks on a couple of other issues. But before I do that, I'd like to really commend the organizer of this event for organizing this, and in particular for organizing this here in Italy. And I say that because Italy, of course, is a country I know very well. It's a country where I have arbitrated many cases. In particular, at the Benedetta is here at the Milan Arbitration Chamber, an institution which is really dear to me. I have sat in the council of the Milan Chamber for, I think, 8 years, a long time, so I'm very close to the Milan Chamber. And Italy is also a country in respect of which I'm convinced that it should have more recognition and more visibility than it has today on the international arbitration plane. And there are perhaps a number of causes where Italy is underrepresented on the international arbitration market. Certainly, there are not enough Italian law firms which are dedicated to international arbitration. And the Italian largest law firms would normally tend to merge arbitration in their litigation departments. I have the sense that there are not enough large Italian law firms having a dedicated arbitration department. Another cause of why Italy may be lagging behind on the international market scene is also perhaps the pervasiveness of the judicial culture amongst counsel, and of course the rather poor record of the Italian judiciary in supporting arbitration. But things are changing. The Milan Chamber of Commerce, which I mentioned before, has played and still plays a fundamental role in creating a favorable and dynamic arbitration environment. They have almost 20 years ago, I think, created the Milan Club of Arbitrators, which is an institution which has done a lot to increase the visibility of Milan, in particular, and Italy in general, on the arbitration scene. And also the Milan Chamber has, since a very long time, reserved 2 seats amongst its council to non-Italian members, which has also been an excellent initiative. Institutions and groups such as the Italian Arbitration Association, Arbit as well, have played a very important role in recent years by expressing the rise of a new generation of arbitration practitioners willing to gain visibility on the international scene. And I should also mention but there's no time to mention them all. The number of recent initiatives in Italy which are aimed at opening the Italian market and projecting its talents abroad. And the new Italian arbitration statute, although it is not entirely satisfactory on all planes in many respects, it certainly improves the arbitration legal environment, in particular by introducing the requirement of a declaration of independence and impartiality for arbitrators, and also by introducing a much more efficient system for the recognition of foreign awards based on an enforceable recognition decree by the president of the competent court of appeals. All this is good and goes in the right direction. I'm sure that Italy will continue to go in the right direction, and this initiative, of course, greatly contributes to that. So the topic of this conference is to discuss the specificities of technical disputes and their quantification. And I would like to say a very few brief words about this. And perhaps we should start by asking ourselves what the technical dispute is. And of course, although the term dispute has a legal meaning, there is no legal definition of the terms technical. Although many contracts, in particular in the construction field, would include arbitration clauses that distinguish and provide for different avenues in case of what is defined as a technical dispute and what is defined as a legal dispute. But for the scope of this discussion today, it is perhaps enough to say that a technical dispute is a legal dispute arising from a contract and which essentially rotates around one or more complex technical or engineering issues. And there are, of course, we of course all have many possible examples of these kind of disputes. I have years ago been involved in an arbitration related to the failure of certain electromagnetic compatibility tests, which are tests that take place at the very last stage of the assembly process of the satellite before launch. And that test had failed, it had resulted in fire, and the arbitration was about the causes of the reasons why these tests did fail. Another example could be why there is corrosion in a turbine boiler, for example, something which is of certain actuality now in particular in the nuclear industry in France. The causes of an airliner crash. I had the privilege of participate in an arbitral tribunal who had to deal about the reasons for the crash of an Air France jet from Rio to Paris some years ago. You will remember that. So another possible example would be, I have been involved recently in an arbitration where there was a failure of a large turbine with experimental large size blades, and one of these blades failed, and all these involved of course complex scientific, complex engineering questions. In most of these cases there will be a contractual provision excluding or limiting liability, save in case of gross negligence, of course, and the question in this arbitration will be whether such limitations apply, and that will depend on the finding by the tribunal of gross negligence, which will in turn turn around a number of highly technical assessments. Of course, the tribunal will have to identify the technical causes of the accident, and there will be different views between the parties on that, but then the tribunal will also have to assess whether these causes were foreseeable or should have been foreseen by a reasonable and diligent operator, which will require for the tribunal an analysis of the state of the art, of the knowledge, of the technical knowledge at the time of the accident. And all this will require arbitrators not only to digest a considerable amount of highly technical data, but also to understand the underpinning engineering, scientific and technical concepts and theory, which of course is not easy for arbitrators. Normally are jurists, professors of the law, advocates. We are not normally trained to understand issues such as those which I have mentioned. And there is a question, therefore, that arises on the part of counsel, which is a question of pedagogy. And that question includes how best to use technical experts, because in all these disputes, there will, of course, be technical experts. And the way in which this is normally done in arbitration is, of course, by submitting party-appointed expert reports and responsive expert reports amongst all the other evidence that the tribunal will have to consider. But the backdrop of that, I would say, almost boilerplate procedure that we have is that it may not always allow the tribunal to focus enough and early enough on these highly complex technical, engineering, or scientific issues, which will and are, in fact, threshold questions in the arbitration. And in this regard, I would like to make 3 or 4 suggestions. The first is that I would like to stress the importance of organizing, whenever that is practicable, a site visit with the parties, with their engineers, and to do that as early as possible in the day, not at the end of the taking of evidence, as it is sometimes done, not at the time of the evidentiary hearing, but before that. And I say that because such a visit can be hugely important when it is organized early enough to allow the arbitrators first to discuss with engineers. Of course, this is a time where they will be at the very beginning of the learning curve. They will know almost nothing about the problem, but by seeing the animal, by seeing the beast, you will have a visual beginning of understanding that will allow you to have a better grasp of the general technical environment of the case. Why are these problems arising? And before identifying the cause, you need to see it. You need to see what happened physically. And by doing this, an arbitrator will have a better understanding of the issues that will be discussed in the expert reports. I don't say that this is something that should be organized systematically. I say that it might be a good idea. Consider doing this. When the arbitration starts, consider if it is possible again, and that's something that can be done, of course, physically, but it can be done virtually, it can be done by video, it can be done by the use of drones now, but consider bringing the arbitrators, getting the arbitrators to see the site, to see the machine, to see the turbine, to see it in operation, to see if, I was mentioning this arbitration where an experimental large size turbine blade failed, to see the blade, what it looks like. And by doing this, when you will get to read the expert report, you will have a much better understanding of what happens. It is always more difficult to understand the functioning of a complex industrial process if you have not seen it. Of course, you will understand in the end, but you will understand it on the papers by reading expert reports, and that is less visual. That is more difficult. And if you have that site visit, that's also an opportunity for you to raise questions. That may be stupid questions at the beginning, because again, you're at the beginning of the learning curve, but these questions are questions that will then inform your further understanding of the case. The second observation relates to access to information. And I say this because in matters where there is a large industrial sinister damage, an accident, an industrial accident, access to information is, of course, critical for the claimant. The claimant would be the client, the purchaser of a satellite, for example, the purchaser of a turbine, who is the victim of an industrial failure. And an arbitration will, of course, or may start years after the accident occurred. The engineers that have been involved at the time of the accident may no longer be around. People may no longer be around, but the documentary record will still be there. But that record will, of course, normally be in possession of the industrial operator, not of the claimant. An industrial accident will very often result, it is so in the aeronautics industry, it is so in the satellite industry, it is so also in the energy industry. There will be an inquiry commission. the operator will, when there is a large accident, constitute an inquiry commission. That inquiry commission will be at times open to representatives of government agencies. Sometimes it will often not be open to the client. And that inquiry commission, what will it do? It will perform an inquiry, of course, and try to identify the causes. There will be a report. The report will be released to the client, the claimant, but the client would often not have access to all the underlying documentation, the interviews with the engineers, all the supporting documentation will normally not be, or at times not be, I've seen that many times, available to the claimant. And therefore, that is why access to information for the claimant at an early stage may be important. Now, what normally happens in arbitration, as you all know, is that documents disclosure take place before the 2 rounds of submission, assuming that you have a continental style, memorial style form of procedure, statement of claims, statement of defense, and then you will have your reference schedule and the disclosure of documents, and then a 2nd round of submission, which means that in certain cases for the claimant, you have to file your statement of claim in the dark because you don't know. I mean, you know that an accident occurred, you know that your satellite went on fire, and that has caused a delay in the launch of the satellite, but you don't know why. You know that there is a report. The manufacturer of the satellite has concluded that the cause of the satellite was an unforeseeable, irresistible event due to God knows what, but you have no, of course, very limited ability to check that. And therefore, what you will see is that in some instances, the claimant will want to have an early access to these records. They will ask for an opportunity for documents disclosure even before the statement of claim. And that normally will be, that kind of demand will normally be met with some level of reluctance on the part of the arbitrator, for essentially one reason is that the arbitrators will feel that they are unable at such an early stage to assess the relevance of documents that may be requested, because you don't have the statement of claim. You may have a notice of arbitration, which may be more or less developed, which often would be quite succinct in this, at least in this kind of scenario. And therefore, arbitrators will be reluctant to allow a round of requests to produce before the statement of claim is produced. But what I say is that there may be instances in which that reluctance is ill-placed. It may be ill-placed, again, if the arbitration is a highly technical one, rotating about highly technical, scientific or technological issues. In particular, if there has been an inquiry commission, if we know that there is a record for the works of this commission that is not available to the claimant, in these circumstances, it may be proper to put the parties on the same plane as far as access to information is concerned, and allow the claimant to get access to this information at an early stage before it files its statement of claim. Because if you don't do that, then you might have problems, you might have delays, you might have new information coming in at a late stage, which is of course disruptive in the arbitration. The third observation goes to the taking of the expert evidence itself. And as we all know, the normally used procedure in arbitration is a submission of expert evidence by the parties, party-appointed expert reports, which is fine. Nonetheless, there is, and particularly in this country, in Italy, there is very often an expectation on the part of counsel that the tribunal will appoint its expert, what is called here a CTU, a consulente tecnico d'ufficio, and I've seen that many times in arbitrations with Italian colleagues and Italian parties, which say, oh, well, the tribunal should appoint the CTU. Why are you going to allow the submission of party-appointed experts? It's for the tribunal to appoint its experts. And again, arbitrators will be, or are international arbitrators, non-Italian arbitrators in this particular case, may be reluctant to allow this for a number of reasons. The first is that the appointment of a tribunal expert, of a CTU, may be burdensome. it may be burdensome to manage. If the issues are very, very narrow, and there are a limited pool of experts, in particular in presence of large players in the industry, there will be the potential for conflicts or for challenges or for objections to the experts. And tribunals also think, and I think in large part rightly so, that experts are not normally very skilled in conducting an adversarial process as the one which takes place with a tribunal appointed expert. Because of course, if you're a tribunal appointed expert, you need to allow each party to present his view, you need to allow each party to have an equal opportunity to do so, and it converts at times in an arbitration within the arbitration where the experts fulfills the role. It's not that role, but almost the role of a decision maker. The second reason is the increased cost and complexity that derives from the appointment of a CTU, because of course you will have the tribunal appointed expert, and each party will have its own party appointed expert to assist the tribunal expert. And finally, there is a fear on the part of arbitrators that in a way or in another, they would feel bound by the conclusions of the CTU. So all this creates an environment which will, in general, explain that an international arbitrator, in particular if it's not Italian, would be reluctant to appoint a tribunal appointed expert, and these reasons are perfectly understandable. However, what I would like to say is that there are instances in which consideration should be given to the appointment of a tribunal expert. That would not be the case for quantum, for example. I think that's not a good idea, but that may be the case for highly technical, highly scientific issues. For example, whether the metal that has been used for the manufacturing of a blade, of a turbine blade, was proper or had certain qualities is something that is narrow and can be, I think, usefully the scope of a tribunal appointed expertise rather than of party appointed expert reports. The fourth observation goes to, again, the expertise procedure itself. And we are here in a scenario in which there are party appointed experts. And what we see in arbitrations too often is that there is not enough consultation between the parties and the tribunal at an early stage on not only the format of the expert reports, but also the instructions. And you almost never see tribunals asking asking parties to provide their party appointed experts with common instructions. That is not doable, again, I think, for quantum, because quantum is highly dependent on instructions on points of facts, which will necessarily be divergent for one party and the other. But again, if we talk about highly technical questions, such as the one I just mentioned, and there are many like this, it is perfectly conceivable to get the parties to provide common instructions to party appointed experts. And giving common instructions to party appointed experts will allow the tribunal to ask that the party appointed expert reports will be drafted in the same format, with the same presentation, with the same chapters and sub-chapters, and that in turn will make it much more easier for the tribunal to direct the submission later on of joint reports, which is absolutely necessary in some instances, and to examine the experts in the form of a joint conferencing together. You have reports which are made with the same template, based on the same instructions by the parties or common instruction by the party to both experts, and that will facilitate the life greatly of the arbitral tribunal. And the last observation I'd like to make goes to the timing of the discussion between the parties and the tribunal on these technological or scientific questions, and the opportunity or not to front load them. And what you see is that The question of bifurcation, of course, is always is frequently discussed in arbitration. It is very often discussed concerning quantum. Normally, bifurcation would mean bifurcation of quantum. That is very often the starting point. It is much rarer that the parties would consider bifurcation of bifurcation of liability. I was saying parties would assume that liability, jurisdiction and liability would bifurcate. Jurisdiction would be discussed first, and then liability and quantum. Bifurcation of quantum itself is less frequently discussed, but bifurcation of a narrow technical issue is almost never considered. And I think that is something that should be rethought. If an arbitration turns around very complex technical scientific questions, these questions will be threshold matters for the tribunal to decide. Now, assuming that there is no jurisdiction question, once you go to liability, it may be useful for the tribunal, instead of dealing with these technological matters amongst all the other questions that will come. It may be useful to front load them and to discuss them at an early stage, to isolate them. So let's first see what the answer to these technical questions are, and then we will draw the consequences in terms of whether there has been gross negligence or not. But let's do that at the beginning, because that's a way of allowing the tribunal to give more attention, to dedicate more time to these questions. So you're in a situation in which you have no jurisdictional issue, or jurisdiction has been bifurcated. But then when you come to liability, have a discussion between the tribunal and the parties on how you want to deal with it. Do you want to deal with it all together, with all the other issues? There may be tens of other issues, or do you want to front load this question, isolate them, and deal with them at an early stage? So this is what I wanted to say. In conclusion, what I'd like to submit is that these arbitrations involving highly technological questions require tailor-made proceedings more than we use to do in order to allow arbitrators to, and again, as I said, arbitrators are not engineers, they're not scientists, to allow them to have at an early stage a proper understanding, not only of the technical causes of an accident, but also of the what I call the scientific and engineering environment, intellectual environment of these questions, and to understand the concept, to understand the theories that underlie the parties' arguments. Thank you very much.
Thank you very much, Alexis. I think some points of thought already about how we might, as you say, bifurcate the liability side is I think quite an interesting thing to break out technical before looking at quantum. So hopefully we're starting to learn stuff. Michael McElrath will be